Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Um, I am keeping my Twitter account open, so you can tweet to me during this call. My Twitter handle is immigrationcom, no dot, immigrationcom. You can also go to immigration.com, and on the right-hand side, you see my Twitter feed. You can actually tweet to me from over there. While we are talking, if something comes up, you can tweet. Yeah, the tweet feed is also available on immigration forums. So forums.immigration.com or immigration.com or directly to my Twitter account. That said, I want to point out one thing to you folks, and I hate to do this, but I did tweet this morning. I will not be able to do any new phone calls today. I think chances of me having the time to do that are slim. Unless something is very urgent, you can tweet to me if there's something very urgent. I'll do my best to accommodate you. Um, but I am going to go into the posted questions, answer those, and answer follow-ups to the posted questions. I'm a little pushed for time this morning. So unless something is very, very urgent, I will not be able to answer any new questions today. And I did tweet that this morning. Also, I put it on Google+. Okay, let's start with the frequently asked questions first. There are a whole set of questions relating to H-4 EAD. Before I get started on that, there was a lawsuit filed uh, by an organization in Washington, D.C., trying to stop the H-4 EAD regulations from coming into effect. And I have made some comments about that. If you go to my blog on immigration.com, you will see that I have an entry with a attached PDF copy of the complaint, the lawsuit that has been filed, with my comments on it. And my feeling is this is probably not going to go anywhere. So I'm not that worried about this lawsuit. Also, somebody tweeted to me today asking me if in the lawsuit against the H-4 EAD in Washington, D.C., they were going to ask for some sort of a preliminary injunction to stop the EAD issuance beginning May 26th. So far, I have not seen any sign of it, and I doubt very much that the courts are going to be inclined to give a preliminary injunction in this lawsuit. There are some very strict rules about preliminary injunctions. The lawsuits can go on, but if they want to stop government from acting, there's some heavy burden of proof there, including the balance of equity being in favor of um, immediate issuance of some kind of a stop order against government. So I'm not that worried about it. Don't just prepare for your H-4 EAD. If tomorrow something changes, we'll keep you informed. I doubt very much this lawsuit is going to be an impediment, so don't worry about it. Let's get into the frequently asked us questions. One is from Praving H-4 EAD filing while H-1 extension is pending. So I've got my I-140 approved, but my H-1 extension is pending. Can I apply for my wife's H-4 EAD? And the answer is probably yes. But if you want to be even more circumspect and kind of just hedge all your bets, you could even premium your H-1B. I mean, if you're that concerned about it, you can premium your H-1B. So a lot of these things have not been clarified. They are fine-grained N-degree issues that have not been addressed sufficiently by the government so far. But we do expect them to issue some clarifications before May 26th. Hopefully, a lot of these issues will be covered. Until then, the practical approach is, I believe you could apply for H-4 EAD while the H-1 extension is pending, and you could, based upon the approved I-140, ask for the H-4 EAD, but in the meantime, you can also premium your H1. Okay. Let's go on to the next frequently asked questions. So here the issue is, if there are two spouses, both have H1, is it a good idea for somebody to convert from H1 to H4 EAD? And I have told people this a couple of times before, I'll repeat it. I would say that I think you should hold off. Don't give up H1 to go to H4 EAD. There are a couple of issues here. We don't really know how far the government is going to go into investigating these cases. Are they going to go into details of the H1 status? If not, it could be a simple matter to get H4 EAD. If they start getting into status issues, we could be looking at a protracted battle over the EAD issue. Okay, so just keep that in mind. Ananta Tripathi, I will actually come back and answer the rest of your questions, but I wanted to focus first on the frequently asked questions. So people who are thinking of going from H1 to H4 EAD, I would suggest hold off for a couple of months. Let's see how the government is dealing with the EADs. And if they are asking for too much information, you may want to not file for H4 EAD. I mean, not convert from H1 to H4 EAD. Next, excuse me. Next question. There is a whole slew of questions from Rishi Garg about H4 EAD, what kind of documents are needed. So, what are the documents I must have? Date of birth. Well, so far, it appears to me, and again, we don't have the details yet, the very least you will need proof of marriage. Birth certificate, I don't know. I don't think that's the normal requirement, but I believe proof of relationship should be acquired and kept. Then you have a question, what if the names on birth certificate and passport are different? We still don't know a whole lot about these issues. I would say an affidavit explaining the discrepancy and probably making efforts to remove the discrepancy, whether you want to have the passport issued under the correct name, or whether you want to have an Indian court give a declaratory judgment of some kind that the name X and the name Y are the same person. Something like that would be a good idea. But it's not going to stop your H4 EAD application, at least in my mind. What else should we get? I think even education certificates are irrelevant, because the H4 EAD is not given based upon what degrees you have. It is given based upon your relationship to the H1 holder, who is at a certain level of maturity in the green card process. Okay. Then I'm not worried about the laminated original documents. That doesn't bother me. Again, like I said, I don't even know why education would be relevant for an H4 EAD. So how long would the EAD be given for? Would it be coextensive with whatever time is remaining on the H1? Well, that I think is legal common sense, if there's such a thing. Because if your H4 is only valid until the H1 is valid, I don't think the EAD validity can go beyond that. Government can do it if they want, but I think it's very unlikely. I think they will be able to issue, again, I do not know. It's so difficult to predict. This is an interesting question. Because if they're going to issue the EAD, might as well as do it for 2 years. But are they going to do it that way? We don't really know yet. So I'm not going to be able to answer that question intelligently. One part of me feels it should be coextensive with your H1 status, H4 status. Another part of me feels they could do it beyond status. So I don't really know. And I don't want to just make a guess. If Then the question is, my H-1B after 6 years is expiring in December. Oh no, I already covered that. If it's only valid till my H-1B is valid, would you recommend we file for EAD after my H-1 extension is filed? It's a little early for us to address these questions. I don't really know. Um, Hang on a second. I've got a couple of tweets. Um, oh, okay. Okay. These are just people retweeting something I had done. I just want to remind there's about 4 or 5 people who just logged in. I just want to remind everybody I tweeted this morning and sent a message out on Google Plus. I will not be able to deal with any new questions today. I can only deal with posted questions and follow-ups on the posted questions. I'm a little pressed for time today. Unless your case is very urgent and it cannot wait, tweet me if that is the case. My Twitter handle is immigrationcom. Okay, you can tweet me from immigration.com homepage as well as forums. The Twitter feed is on the right-hand side. I'm keeping my tweets open, but only if it's very urgent. Okay, let's just go ahead and postpone your questions to 2 weeks from now. Going back to Rishi's questions. Rishi, it's like I said, it's a little early to decide which way you should go. Let's just wait and watch. Keep all your options open. Whatever you think needs to be fixed in the meantime. I think the issue of name discrepancy, at least start working towards making things consistent, whatever that takes. Speak with your lawyers. You can consult with us. I can try to give you some guidance. But try to remove that discrepancy if you can. At least make the effort. Then the next question is, would it be first come, first served basis? Well, first of all, USCIS just roughly follows the first in, first out rule. They are not always bound by that rule because there are so many variations within processing times. If it is given to a particular officer, what is their caseload? What if they have to take a couple of days off? It's not always predictable that it will always be first in, first out. Approximately how much time? Well, under the regulations, USCIS should adjudicate EADs within 90 days. But in case you guys don't know, they are finding it very difficult to keep to that time. Okay. So I do not know when they get hundreds of thousands of new applications, are they going to be able to keep that to that time? Have they the resources for that? I would be surprised, frankly, if they're able to keep to the 90-day process. But if it is merely an administrative process and there's not a whole lot of investigation involved, then I don't see why not, but I don't really know. Okay. If I happen to change my employers and my green card process is reinitiated, will she still be eligible for H-4 EAD? And the government has said, as long as you have one I-140 that remains unrevoked, they will give us the H-4 EAD. But if the I-140 is revoked, then H-4 EAD will not be given. Okay, I think I covered all your questions. Let's see. I think there's one or two more H-4 EAD issues. Let me just make sure. Yeah, here it is. Oh, is it possible to expedite an H-4 EAD? And I do not know. But let me tell you this. When you look at the expedite criteria for any government document, they are basically the same. Basically, if you can show government error or economic necessity or emergency or some kind of humanitarian considerations, there's 5 or 6 criteria. They apply across the board. So as a matter of general observation, I think it should be possible to expedite H-4 EAD if you meet the requirements. Is the government going to take that away from H-4 EAD? So far, they have not. but is it within their power to do so? Sure, sure. So theoretically, at least, it's possible to expedite the H-4 EAD. Okay, I have covered all the H-4 EAD questions. If you have posted a question on H-4 EAD and you have a follow-up, please go ahead and press *5. Posted and a follow-up. No new questions. As I have announced both on my tweets as well as Google Plus and this morning, I will not be able to deal with new questions. I am pressed for time. I'll only do the questions that have been posted. Press *5, one question so far. If you have a follow-up on posted questions, okay. Let's deal with the one question. Go ahead, please. Go ahead, I can hear you, or I should be able to. Say hello. I unmute.
Sorry, I was mute.
Oh, okay. Yeah, go ahead, please.
Can you hear me?
I can hear you, yes.
So this is regarding the last question of expediting the process.
Right.
So if we have offer already in hand, should we apply with the application or should we wait for the receipt and then apply?
Currently, the expedite process works both ways. When we expedite an EAD, we either send expedite request with the EAD, or we wait till the receipt comes and then we open an expedite request. It works both ways. So again, too early to decide. Recently,
So should we write a letter with it or?
Yeah, there's a letter along with whatever evidence you have for the economic necessity or whatever the urgency is. You can certainly attach it with the EAD itself. And I always have our team follow up with a service request also. Just let them know we have already asked for the expedite, but we would like to open a service request and put in an expedite request through that as well. Okay?
Okay, thank you so much.
You're welcome. Good luck. Okay, so we have covered the H-4 EAD. Let's go back to the very first question and start taking all the posted questions. Excuse me, folks. So Justin says, I'm here on H-1B. I-140 is approved. You're concerned about a skin condition called, I guess it's pronounced vitiligo. Look, that's not a ground for any problems in green card or even H-1 process, because USCIS is concerned primarily with two issues when it comes to health-based grounds. One, is it contagious? If it is not contagious, we're not worried about it. Two, is it an issue of public safety? For example, if somebody has schizophrenia, as long as they are not violent towards people and property, and their condition is under control, we are not worried about it. Let me just double check my tweets. Okay, somebody had a couple of questions answered urgently. Yeah, Jagan, I will take your questions. If it's urgent, certainly. But I like I said, I'm pushed for time. At the end of the conversation, I'll take your questions. One thing I'm concerned about, since your identity has been revealed, if you want me to call you back, I can do that instead of dealing with your issues on open forum, or at the end of this conversation when everybody hangs up, I'll stop recording and we can take your questions. Okay. Next is stay on the line. Okay. I am here on employment visa. Okay. So Justin, I'm not worried about it. I don't think medical exam would be a problem for you. SP says AAO handed down a precedent decision ruling that change in worksite requires amendment. This has been the law for the last 7 or 8 years. Okay. I'm not sure why people keep saying it's a new issue. Go back to my blog postings going back 7 or 8 years. We have been saying this. Every single one of our clients knows that amendments are required. when there is a change. Let me explain to you the law very briefly. In H1 cases, you are always required to file an H1B amendment. Always. If there is a change in your H1B, whether it is location change, client change, vendor change, third tier change, fourth tier change, you've got to do H1B amendment. Only exception when you don't have to do an H1B amendment and a new LCA should be enough is if it is the same project, same client, same job description, same everything, and the only thing that's changing is the physical location of the job and it is within normal commuting distance. There are some new people who have logged in. Folks, I want to remind you guys that I won't have time to do new questions today unless something is extremely urgent and it cannot wait for 2 weeks. I'm a little pressed for time. So no new questions. If your case is urgent, you can tweet to me, immigration.com. Jagan, you can also tweet and let me know if you want to do it, do a conversation privately, or it's okay to do it on a recorded phone call. Okay, going back to the issue of amendments. So H1B amendments are always needed. The only time you do not need an H1B amendment if it is the same project, same client, same everything, and only relocation is within the same wage area for about 10, 15, 20, 30, 40 miles, normal commuting distance. Okay, that's always been the law. There's nothing new here. For many, many years, that's the way they've looked at it. Anant Tripathi had one part of his questions dealing with H-4 EAD, which I already dealt with. But let's look at the rest of Mr. Tripathi's questions. I-140 was approved 2011, came to USA 2008 on L1, converted to H1, got extension, but only for 1 year, 10 months, even though the I-140 was approved. I'm thinking of joining another company. What should I consider before I transfer? Okay, I think, Anandji, what you should do is, if you're going to change employers, I think you should wait to change until the H1 is actually approved. I think you'll get 3 years, but wait until the H1 is actually approved. Remember, one approval does not overrule an existing H1. So if you are working for your current employer on H1 and the new H1 gets approved, you don't have to join them right away. You can give a 2-week notice after that, or even longer. So I think that would be the only thing I would recommend. Okay. This is a very open-ended message. Came from Ukraine, need consultation how to get a green card. That's a 2-hour discussion. I would say, please, Tara, do some preliminary homework. You can go to our website. Plenty of other websites have this information. Find out what are the various grounds of green card, and then when you have narrowed down the field of the possibilities that apply to you, you can ask us more focused questions. Jerry says he has a slightly complicated situation. So in Jerry's case, what happened was, the dispute is, when is a degree considered to be complete under immigration laws? Is it when the degree is actually awarded? Is it when you finish your coursework? Or is it when you pass your exams? I think I agree with the government. It is when you pass your exams. Without passing your exams, you cannot say my degree is finished. And certainly, we've had cases where the conferral of the degree was 2 years down the line, but the requirements, including the exams, were cleared earlier. We always produced evidence, including letters from school, and those letters were accepted, and we did not have to go to the date of conferral. So I think in your case, a degree is complete only when the exams are passed. I don't think you have to wait for the conferral of the degree to consider that the degree is complete. But certainly, before exams, I don't think you can take the argument that the degree is complete. That's my conclusion. The law can surprise you, but I don't think there's any surprises here. So if I were you, I would look at other options, including refiling the case. I don't think this one is a winner, and I don't think you're going to win if you go to court over this. That's my judgment. Next case is from Jerica. Sister came to USA on H-4, applied for change of status to F-1, still pending. Now, employer is applying for H-1B, so when you have this situation, if she gets picked up in lottery, I think you'll have plenty of time. Once the case gets approved, I'll say premium the H-1 if it gets picked up. Premium it so that you know well before October 1st that her H-1 is approved, and then just, I guess, withdraw the F-1 application closer to, I would say, September 25th or so. Okay, I think that should cover you. Folks, I see that some new people have logged in. I will not be able to take any new phone calls. I will only be able to answer questions already posted. If you have something urgent that can't wait for 2 weeks, okay. All right, Jagan just tweeted to me. Jagan said he doesn't mind answering the questions in the recording and be publicly visible. Very good, Jagan. I will start with, once I finish everybody's questions, I'll start with you, okay? Only if your questions are very urgent, tweet to me. I'll try to deal with it today. I am a little pushed for time. I would appreciate it if you can wait for 2 more weeks for new questions to be answered. Okay, so Jerry, I would say premium it. And the fact that while this case was pending, status change from H-4 to F-1 doesn't bother me. I won't worry about it. You can let the government know if you have a receipt number, open a service request, let them know. I don't think that's going to be a problem. Don't worry about it. Mr. Reddy, Raghav Reddy says 2008 priority date I-140 was declined. See, Mr. Reddy, the problem is unless the I-140 is approved, you don't get a priority date. Filing of perm, approval of perm, they don't give you a priority date. Only approval of the I-140 gives you priority date. By the way, guys, share this with other people also. Recently, I'm looking at a trend in government decisions, which is very alarming, which says that if the I-140 is revoked, even if it is revoked by the employer, we'll take away your priority date. Last 5 years or so, or 3 years or so, they have not done that. They used to do that before, then they went to saying, okay, the only time we'll take away our priority date on an approved I-140 is if the I-140 is revoked for error or fraud. Now they are saying even if the I-140 is revoked for by the employer, we'll take away our priority date, which is, I think, problematic. Okay, so I'm seeing these decisions. I've done 2 consultations in the last 2 weeks on this. So this is an alarming trend. Keep an eye on this. This may become the USCIS standard policy. Okay. Owen Raz says, I am F1 OPT will expire May 11th, applied for H-1B. What do I do about driver's license? The problem is, Owen, this is an issue that can only be addressed by the local DMV. So I would suggest you contact a state legislator. So if you, for example, live in Virginia, you live in Fairfax, contact the state representative, not federal government, not federal Congress, state legislator. Like in India, we have MLA, okay? Not the MP, not the member of parliament, but MLA, Legislative Assembly. Contact them and see if they can help you resolve this issue with DMV, to explain to them that when OPT is pending, you are still considered to be in status for 60 days. After that, if you have an H-1B pending, you could take advantage of the cap gap extension. So see if that can work, okay? Next question is From Jeff, who says I was involved in a false case of domestic violence. And he's got the law down correctly. The law is that if you get convicted of a felony involving moral turpitude, you will be deported. And if you get deported, you can't come back for 5 years. If the felony is something called aggravated felony, then you are deported and you will be gone forever. You can never come back. But if it is one single misdemeanor ever in your life, it is forgiven without any problem under what is called a petty offense exception. So Google that, petty offense exception. Petty as in small, P-E-T-T-Y. And you're right that even though under state law, criminal law, it may not be a conviction, but if you have admitted guilt under immigration law, that's a conviction. I don't have anything to add to that. You've got the correct statement of the law. But if it is possible for you not to have to admit guilt or to plead guilty to a simple misdemeanor, that would be probably your best bet. But don't take my word for it. These things are very, very complicated. Get lawyers involved. If you have hired a criminal defense counsel, work with them to find an appropriate immigration lawyer, preferably in the state you are in, because it will involve knowing the criminal statutes of the state you are in. And we can do it, but then it involves a lot of research on our part. You'll be better served by somebody local. But if there is nobody, then you can certainly contact our office. This is not an easy situation. Okay? I cannot give you a 5-minute judgment on this, but you got the law right. That's good research. Eliev, as is John, Eliev says, I hope I didn't mispronounce that. I went to USA with a J1 visa, came back, then stayed for 5 months on a tourist visa, or a little bit over 5 months, but left before my I-94 is expired. Now I'm planning to go back again in August. You're coming back too quickly. So you left in March, you're coming back in August, they can refuse you entry. Okay? As long as you did not violate your previous stay maximum amounts, it does not create any problem for you. But what does create a problem, that you stayed 5 months, left for a couple of months or 4 months, and you're coming back again so soon, I would be concerned about that. You're just coming back too soon. Okay. I also want you to remember that in order for you to serve out your 2-year home residency requirement, you have to actually stay outside USA in your home country or the country of last permanent residence for 2 years, full 2 years. Okay. And if you come too frequently, they'll make you start the 2 years all over again. Shauna, H4, H1, H4, H1. So first of all, Shauna, if you go on maternity leave, I think your employer will have to revoke the H1. It is dangerous for them not to revoke your H1. Okay. So you are on H1, you take maternity leave for a year, convert to H4. Your employers can refile the H1 when you are ready to join the workforce again. You will not be subject to the quota. Okay. I think you should let them revoke the H1. It is dangerous for them not to do so. Shauna has, I guess, another question. H-1B amendment. H-1B approved with company B under AC 21. Now the I-140 is revoked. I don't think you'll be able to get an amendment because USCIS could refuse to grant you an amendment since the underlying I-140 is gone. Okay, so Shauna, that's really a problematic situation. Shauna, I can't answer so many questions from the same individual. So you have a third set of questions. So I'll do it this time, but folks, please don't. We close the questions after 22 or so. So if you put so many questions, you're taking away from somebody else. There's a tweet from somebody. Give me 1 second. Okay, that's just new people following us. Let's just see. Perm labor filed. Oh, this is perm labor filed requirement of masters +3 or bachelor's +5. Completed masters. Oh, okay, so the issue is if I have a bachelor's and 12 years of experience, obviously I qualify for EB2 as bachelor's +5. But let's say I've also done master's. Can I also qualify as master's +3? Yes. The experience required for master's does not have to be post-master's. But for EB2, experience with bachelor's has to be post-bachelor's. And that is the law. Okay. So you don't have to have 1 year experience or 2 years experience or 3 years experience after master's. So if somebody came to me and they had finished their master's degree today and tomorrow they were joining a new employer and they have experience only obviously before master's, can I use that experience and get EB2? Yes. But for EB3, but for EB2 based upon bachelor's, the experience must be post-bachelor's. Okay. Next question is Murali Krishna. The only way you can reset the H1 clock is if you are outside USA for 1 year. Murali, so in order for you to reset your H1 clock, you have to be outside USA for 1 year. You cannot do it within USA. If you have no perm applied, there's no other option. People do F1 CPT and all that. Take a look at that. But I have some blog entries on that as well. But there's no way to reset the H1 clock without being outside USA. Folks, a couple of people just joined us. I will not be able to take any new questions unless it is very, very urgent and it cannot wait until next Thursday. Then if it's that urgent, just tweet me. Immigration.com is my handle. You can tweet me from immigration.com homepage as well as immigration forums. On the right-hand side is my Twitter feed. Next question is from Begar. Physician on H-1B cap exempt for past 5 years. I-140 approved. I-485 pending last 60 days. No EAD AP in hand. Won't be able to continue with the current employer. And they are going to revoke I-140. Yeah, Doc, you have a real problem. The problem is if they revoke the I-140, you will not be able to get the H-1 extension that you need past 6 years. 5 years plus whatever time you have remaining you'll get, but not beyond that. Okay. And if the I-140 is revoked before your 180 days of 485 pendency are over, USCIS will not allow you the benefit of AC-21 portability. If the H-1B is revoked, you will be considered out of status until a new H-1B application is filed. More importantly, you will be considered unlawfully present. And if you're unlawfully present for 180 days with no resolution of H-1B status, you will be barred from entering USA for 3 years. Be very careful with that. Unlawful presence, okay? It looks very likely that you'll have to start PERM, I-140, 485 all over again. Okay. If you can convince your employers to wait until after 180 days, you are in a much better shape. Crazy Ben, my PERM job description asking for MS in computer science, math, technology, etc., and 1 year, no bachelor requirement. I have MS in technology management plus 3.5 years of experience. You do qualify for EB2. MS plus 1 is EB2. Will it be audited? I cannot really predict that. I'm sorry. Okay. Next question: are we 1, 2, 3, 4 getting married in Colombia? Parents are not going to be involved. Is this sufficient proof of marriage? Wedding photos in Colombia, joint bank account. Yeah, all of this is good, but hang on a second. If you're getting married in a church, you'll actually get, I mean, if you're getting married in the Colombian laws, you probably get some kind of a marriage certificate from the government also. So I think that should, I'm not sure if you have looked into that, but under the law, if you can prove that marriage was legal in the country in which it was done, that marriage will be recognized by USA. Very, very rare circumstances, like if the bride and the groom were too young and it's against public policy to accept that kind of marriage. Very, very rarely would USCIS refuse to accept that. Okay. So don't worry so much about it because you'll have a certificate, marriage certificate. Get it translated, of course, if it is not in English. Amit says, oh, I have another tweet. Siddharth, is it okay to talk on open line? Because your identity is revealed, so I'm concerned about that. If it's okay, after Jagan, I'll take your call. Okay, I know, I understand it's urgent. I'll take your call. So just stay on the line when everybody else hangs up. We'll just get to it. I'm pretty much at towards the end of our posted questions. Amit says, excuse me, guys. Job change on H-1B few days before completion of 5 years. Should I wait for permanent I-140 to be approved? I would like that, yes. Because that way you get 3 years of H-1. So I would suggest, Amitji, that you wait for permanent I-140 to be approved. And file the I-140 premium processing. Okay. Arjun G. Monica has posted for him marriage after getting a green card. Priority date is June 28, 2008. EAD AP got approved. Got a letter from USCIS last week asking for a new medical exam and employee letter, I guess employer letter. Once I get my green card, it will be challenging to marry a girl from India. Because it can take a couple of years, only US citizens can get okay. So if the life partner is based in USA, either in H1 and green card, should be okay. How can I delay my green card? Well, of course, you can delay your green card by holding off on submitting the response to the RFE that you have received, but only as long as your RFE time permits. If you wait beyond RFE time, then they'll throw out your 485. You do have the option of going on H1, withdrawing your 485, and then refiling it after marriage. But other than that, there are no really good options for delaying the 485. You can withdraw it, convert to H1, and then refile it when the priority date is current again. So withdrawing the 485 is the only other option. Okay, I'm done with these posted questions. No new questions other than Jagan and Siddharth. Any follow-up questions on what has been posted? *5. Press *5. After that, I will deal with the two urgent situations. *5, one question. Two. Okay, good. Excellent. All right. And then I have, three. And then I have only two more gentlemen left. We'll deal with them. Okay. Very good. Very good. Let's start in the order that you logged in. Yes. Jersey City. Go ahead, please. Jersey City. Jersey City. New Jersey.
Sir, this is Jerry.
Hi, Jerry.
I have a question about hello.
Yeah. I can hear you.
I asked a question about the I-140 in EB2, where there was an educational degree certificate confusion with when I got the degree conferred.
Sure.
So you suggested that you would refile the case. So when you said refiling, you mean to say that refiling the I-140 again with the evidence that I completed on
No, Jerry. I think you're gonna have to do. Let me think about this. I think you're gonna have to do the entire case again, unless the language of the perm allows for an EB3 filing. So really, somebody should look at your lawyers should look at the language of the EB3 perm and see if there's any way to file. I'm sorry, the perm, and see if there's any way to file I-140 under EB3. But it looks to me like you're going to have to refile from the very beginning.
Oh, okay.
Okay.
Actually, my lawyer suggested that you would also try the filing in the EB3 category. But yeah, that's again, I wanted to weigh the merits.
Yeah, I'll tell you why I'm doubtful that you'll be able to qualify. Because they have probably written down that a degree is required. And unfortunately, on the date of the filing, you had a degree. It's just that you don't have 5 years. I think you'll get an EB3, Jerry. Okay. Now get the EB3 and then file for an EB2 and then transfer the priority date.
Okay.
All right. You're welcome. Good luck. Okay, one more person has raised their hand. So let's go to, this one is also New Jersey. New Jersey, go ahead.
Yeah, hi. I have a question about this Obama immigration action. Like my 140 was approved in year 2012.
Sir, I have been repeatedly saying I will not deal with any new questions. So, okay, well, you've started talking. I hate to cut people off, but no new questions, folks. Other than Siddharth and Jagan, no new questions. Go ahead. So, Obama action.
Yeah, so my 140 was approved in 2012. Since then, I was holding visiting India because visa stamping issues. But I heard that once this action is implemented, we could get a EAD and we could easily travel to India. But it's not looking anything in near future. So what would you suggest? So if I could go and stamp the visa, or I could wait, it will be implemented in near future.
Unless you are in a very solid company working in-house, no clients, no end clients, I would want you to wait and see what happens.
Is there any possibility this year it will be implemented?
I do not know, sir. I really cannot comment about that. Government says they are trying to move on all these things, but your guess is as good as mine, sir. Okay?
Okay.
Good luck.
Thank you.
You're welcome. Okay, no new questions, guys, please. All right, we got two more raised hands. Oh, this is my neighborhood. Washington, D.C., go ahead, please.
Hello.
Yes.
This is RV1234 regarding cross-trackability. I just have one question. So, for example, the 485 would be filed separately, right? So, for example, if my TB wife has like a history of unauthorized work, so so if a denial happens to her case, so will my I-485 be denied too?
Okay, let me rephrase the question. So the question is, if I am the primary applicant in a 485 and my spouse is my derivative beneficiary, and let us say there is some history of immigration violations in her background with no participation in me of any kind, if her 485 is denied, does it affect mine? And the answer is no, it does not.
Even if I'm using her cross-chargeability, right?
You know, that's an interesting issue, and I think that cross-chargeability does not require that she should also be eligible for AOS, as far as I remember. But without further digging into this I would not be able to give you a definitive answer. My guess is it should not be a problem for cross-chargeability.
Okay.
Okay.
So can I use the services if it can? I mean,
Yeah,
can I
send me an email with this issue, and I'll see if I have somebody available who can dig this up for you, and we'll quote you a fees. Okay.
Okay. Thank you so much.
You're welcome, sir. Bye bye. And the last raised hand is from California. California, go ahead, please.
Hello?
Yeah,
Yeah, this is Amit Jain.
Ji, Amit, 1 second.
So, my question was, yeah, this is Amit Jain.
1 second. Let me pull your question. Okay, you're not on this page. You must be on the last page. 1 second. Yes, sir. Job change, October 2016, 6 years will complete, perm filed. So my question was, should I wait for perm I-140 to be approved? And I said yes. Yes, Amitji, what can I do for you?
So, if I, let's say I wait for perm and I-140 to be approved and they are approved by the end of this year. So, like by this December. So, after December, can I change the job? Once I have 140 and
yes, sir. What I would suggest you do is you go ahead and apply for H1 extension, or I'm sorry, H1 transfer and extension. Wait until it is approved, then join the new employer. You should get it for 3 years.
Okay, so but the extension can only be done with the current employer, right?
No. It can be done once the I-140 is approved. The extension can be done through any employer, even though the I-140 is approved through some other employer.
Oh, okay. So if by December, if my 140 is approved, then I can take that 140 and give it to a new employer, and then they can file for a transfer as well as an extension at the same time.
Yes, sir. That's exactly the way it works.
All right. Thanks a lot, sir.
You're welcome. Good luck. All right, folks. Everybody else, please hang up except the 2 folks that I just said I'll be dealing with. So if you folks, don't have to listen in, we are done with the call this afternoon. We'll see you in a couple of weeks. Let me get to, Siddharth and Jagan, please press *5 on your phones. *5. Jagan, I know what your area code is, so I'll go with you first because you asked first. Okay. 1 second, Jagan. I just unmuted you.
Hello, Rajiv. This is Khanna.
Haji, what's going on? Tell me.
Hey, can I ask you one question in private? I just realized that my identity has been.
Yeah, that's what I was wondering. So yeah, let's do that. Let's do it in private. I actually will give you a call after I finish this. Give me 1 second. Let me, or just call me. Once I hang up, call me 703 908 703 908 4800 extension.
Should I call that number?
Hang on. Extension 110. Okay, no, stay on the phone. When I hang up, then you call.
Can you give me? Sorry, I didn't note it down.
703.
1 second. Sorry about that.
Oh, let me tweet it back to you. I just tweeted it back to you.
Sorry, I'm just out of the computer. 703. Can you tell me?
703 908 4800.
908
4800. Yeah, 703 908 4800.
Okay.
Extension 110. Stay on the phone. When I hang up, then you call because then I'll be finished with this call. Okay?
Okay, all right. Thank you.
All right. Siddharthji, your identity is open to everyone. So if you have any problem with that, you may also want to either call me back or tweet me your phone number or just email me your phone number. Siddharth?
I can accept.
Yeah, go ahead. I'm listening. Please go ahead. Your labor got denied. Your labor got denied. Your H1 is good till September 2015. Appeal deadline is May 16th. Oh, absolutely. Appeal it. Absolutely. See, what happens is once you appeal, you are entitled to get H1 extension for 1 year if your labor cert was filed more than a year ago. So filing the appeal will give you the right to extend for the next 1 to 3 years at least.
Okay. So it will. So usually appeal. How much time does appeal take?
About 3.5 years. You're thinking of Balka, right? Appeal, labor got denied. Yeah. So Balka is about 3.5 years backed up, and you can always withdraw the appeal if you are filing another case.
So my question would be, if I appeal and then I apply for an extension, and then if I plan to reapply, so I have to get off. I have to take away my appeal thing. I have to withdraw my appeal, right?
Yes, but your lawyers can set it up like this that you will have enough time and you'll be safe. Um, they can juggle the filing of the new labor cert and the withdrawal of the appeal and the extension of the H1 in such a manner that you'll have enough time to file a second case. No problem.
Oh,
Okay?
okay. So I can get an extension till it's under the process of appeal.
Absolutely. Absolutely. Okay?
So your immediate would be like appealing and getting it done.
No question about it. If you are close to end of your 6 years or already over your 6 years, absolutely file an appeal.
Okay, and also actually I've also contacted your firm directly for the service.
Okay, sure.
For
You,
the details.
absolutely. How much time do we have? It's April. You said May 16th. We have enough time. We'll be able to take the case.
Yeah,
Okay.
so that's what I'm just hoping like he or she, I don't know who is it.
Hang on 1 second. Let me see. 1 second. Let me. Sumanji, did you get a message from Siddharth Damani about filing an appeal?
The name doesn't ring a bell.
Okay, Siddharth, I'm on a conference call with everyone, Sumanji. Siddharth, send an email to suman@immigration.com.
Actually, I have my HR did an email, Victoria.
Oh yeah, I see Victoria's name here.
Yeah, okay, she's got it. We'll take care of it, okay?
Okay.
All right.
All right.
All right.
So okay.
Sumanji, talk to me after I'm done with the conference in about 10 minutes, okay?
Okay.
All right, bye.
Okay.
I will take care of it. No problem. All right?
I'll just hang up this.
Yeah, hang up now. Jagan, I'm just finishing the conference. You can call me now. Folks, everybody, thanks for being here. I'll see you again in 2 weeks. Sorry I didn't have more time today. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.